Good morning, ladies and gentlemen. Please have a seat. Ladies and gentlemen, today we are here to discuss about the case Salomon versus Salomon. Are both sides ready?
Yes, Your Honor.
Please proceed with your opening statement.
Your Honor, my client Mr. Salomon made leather boots and shoes in a sole proprietorship. His sons wanted to become his business partner. So my client turned sole proprietorship into a limited company. The company purchased Mr. Suleiman's sole proprietorship for £39,000. His wife, daughter, and 4 sons, each with 1 shares, became the subscribers of the company. The company took place on 1st June 1892. My client gave the company £10,000 loan secured by the floating charge over the assets of the company. Soon after my client incorporated the company, a decline in sales fell the company, defaulting its interest payment on the venture. The creditors sued the company to enforce his security in October 1893. The company was put into liquidation and was repaid his £5,000 loan. This left £1,055 company asset retaining, of which my client claimed his retained debenture. This would left nothing for unsecured creditors, of which 7,773 owing. Where the company's liquidators contended that Salomon should be made responsible for the company's debt. As a result, my client sued. Thank you, Your Honor. These are the evidence.
Thank you. Now the defendant may proceed with the opening statement.
Thank you, Your Honor. Mr. Salomon sold his business to the company at $39,000, which price was set by himself, and the price was too high from the market price. He took 20,001 shares among 20,007 shares, and the other members of the company are not involved in any decision making. Mr. Salomon, as a director and as a principal of the shareholder, he took all the decision by himself. As a principal and the director, Mr. Salomon did everything for his own favor, and he took everything that can satisfy himself, not to satisfy the company or the other shareholder. Mr. Salomon financed the operation of the company by borrowing, but the money wasn't utilized properly. Mr. Salomon is a fraud and he is a liar. As a result, the company failed to pay the interest and the borrowing money to the creditor, and it went into liquidation. Your Honor, after the liquidation, Mr. Salomon, instead of paying to the creditor, he claimed the money for himself. This money belonged to my client.
Objection, Your Honor.
Order. Objection sustained.
Your Honor, according to the 1862 Act, limited liability companies as legal persons separate and distinct from the shareholders. So, this Act clarifies that my client has no responsibility to the debt of the company.
Objection, Your Honor.
Order. Objection sustained.
Your Honor, the company is the agent, and as a principal, Mr. Salomon has to bear the liabilities, and he is the only one who is liable to pay my client. Your Honor, allow me to ask some questions to the plaintiff.
You may proceed.
Yes.
Mr. Solomon, how did you sell your business above the market price?
Because the selling price was exact price. I didn't sell it above the market price.
And one more question. I have one more question. Did you abuse your power as a director?
No.
Okay. Your Honor, I have the evidence that Mr. Solomon abused his power and all the money he took from the company he spent for his own benefits. And I wish that the court will take decision against Mr. Solomon.
After looking at the proposal from both sides, the court has decided this argument, ruling that since Mr. Solomon had created the company solely to transfer his business to it, then the company and Solomon were one unit. The company was in reality his agent, and he as principal was liable for debts to unsecured creditors. After hearing all the argument, the Court of Appeal decided that the decision goes against Mr. Solomon on the ground that Mr. Solomon had abused the privileges of incorporation and limited liability. I took the company as maid and a fiction. Solomon himself wanted to carry the company as before, but with limited liability. The House of Lords rejected the arguments from agency and fraud, meaning that the House of Lords rejected the decision from High Court and Court of Appeal. Solomon followed the required procedures to sell the company. Shares and debentures were issued. The House of Lords held that the company has been validly formed since the Act merely required 7 members, holding at least 1 share each. There was no fraud as the company was a genuine creature of the Companies Act as there was compliance and it was in line with the requirement of the Register of Companies. The company is at law a separate person. The 1862 Act created limited liability companies as legal persons separate and distinct from the shareholders. So, Mr. Solomon is not liable for the debts of the company.
Action.
No, this is
Action.
order.